topic, as you all know, will planning is a topic close to my heart. So why is it close to my heart? Some of you here might have already heard my dad's story. Some of you haven't, and you are here to find out more. So let's get started. Okay, first of all, this is a picture. You all probably recognize the person on the right. It's me. I don't think I've changed very much. That was taken back about 8 years ago, back in 2013, at my first promotion ceremony, back when I was still in People's Association. The person on the left, you see a resemblance there, right? It's actually my dad. This is my dad and me very seldom get to take photos because I think he's like the typical Asian dad. He is camera shy. So this was one proud moment that he was actually willing to take the picture together with me. So next picture, you will see the same two person. Obviously, the person on the right is me again. The person on the left is my dad. But you'll notice that he's noticeably skinnier, looks like more creases, looks older. This was only about 5 years later. I look around the same. My dad looks a lot skinnier. It's because at that point in time, he has already contracted renal cancer. People who are not in the know, renal cancer is actually kidney cancer, a rather rare form. So this is also actually my last photo with my dad. So you can see that actually between 2013 to 2016, we actually took 2 photos. I don't really remember other photos. So what happened next? 11.5 months later, my dad passed on. So this is his obituary. So like we understand today, our topic today is will planning. So will planning, one of the parts is by looking at the obituary, we can understand what the living has left behind. In this case, my dad's obituary is simple. He left behind a beloved spouse who is my mom, my dad's wife, and 3 children, myself, my sister, and my brother. So why am I showing this? Is because quite often Asian families tend to be large in total. It's not only just the wife and the children. Sometimes there are son-in-law, sometimes there are daughter-in-law, sometimes there are grandchildren involved, especially if it's the grandfather who passed on. So over the next 20 plus minutes or so, I will bring you all on a journey. Firstly, through a real-life case study of my dad's own will, before going into some of the more technical aspects of what will planning is about. So my first sharing about this is what I always tell my clients: the easier it is to write a will, the harder it is to execute upon death. So why is it so? Typically, Singaporeans' will, when they come to me, they often have this very common line. They always tell me, upon my death, all my assets go to my wife and my children. Very simply done. Very seems like everything is taken care of, right? But it is really hard to execute upon death. Why do I say so? My dad's view, actually, I consider him quite forward-thinking. He was quite clear as to what he wanted to give to who. Why is this so? Let me go through the first instruction of his will. Instruction 1. My 50% of my property goes to my youngest son, which is my brother. So my dad and my mom, like all Singaporeans back then, bought a HDB under joint tenancy. So when he wanted to give 50% of his HDB, means that upon his death, 50% he wanted to give to my brother. His main worry was that my brother would not have a house to stay in if he were to pass on. That's because my dad and my mom are actually on bad terms. So he has this worry there. So take a moment to digest this first. Later, I will come back to this. Instruction 2, all my CPF money goes to my elder son, which is me. Also sounds very simple, right? So take a moment to digest this. Later, I will come back to this also. Third instruction, all my bank account money goes to my daughter, which is my sister. And essentially, that's it for my dad's will. You'll realize there's one person surviving that is missing from the will. That person is my mom. So one thing why my dad didn't leave anything for my mom is because firstly, they were on bad terms. But also secondly, my mom actually has an inheritance from her grandfather, which is 90% of the HDB proceeds from her own father. Therefore, she is deemed financially self-sufficient. So my dad's idea is to take care of the 3 children. Okay, so 3 very clear-cut instructions seemingly. So why do I say the easier is to write a will, the harder is to execute upon death? So let's go back to instruction 1. My 50% of my property goes to my younger son. No issue, right? But remember I mentioned most Singaporeans who buy a HDB are under this thing called joint tenancy. Under joint tenancy, it is based on this rule called rule of survivorship. Upon the death of one joint owner, the surviving joint owner actually gets 100% full ownership of the property. So what happens to this instruction? My dad wanted 50% of the property to go to my brother. Upon his death, my brother gets 0%. My mom is now 100% full owner of the property. And remember, my dad didn't want to leave anything for my mom. Instruction 2, all my CPF money goes to my elder son, which is me. So also sounds easy. And I think nowadays the government has been pushing hard for CPF nominations and distribution, etc. So we are more savvy nowadays. Unfortunately, back in 2015, I wasn't in this industry yet. I didn't know that CPF monies are not governed by a will. So you cannot will away your CPF monies. The only way you can distribute your CPF money is by going to the CPF board to do a nomination. So if there is no nomination done upon death, what happens? In this case, my dad wants to give me 100% of his CPF money. But what really happened upon his death? It goes to this law called ISA, Interstate Succession Act. It states that upon the death of a husband, the surviving spouse gets 50%. The remaining 50% gets divided equally among the children. In this case, that's 3. So the instruction is 100% give me. But what happens at the end? My mom got 50%. I got 16.67%. So this didn't also follow the instruction that he wanted. So lastly, all my bank account money goes to my daughter, which is my sister. This instruction actually is very valid. Totally no issue. But what is the issue here is that actually we had a family business. My dad was one of 3 partners. So back then in this family business, he wasn't advised to actually keep his personal bank account and corporate bank account separately. My dad was the main person running about garnering sales for the business. He was the main businessman, but he never participated in profit sharing. And quite often, company monies go in and out of his personal bank account. So upon his death, we then discovered across the course of his cancer in that 11.5 months, we realized that all our company assets are actually under mortgage. So there is no real cash at the moment. And upon my dad's death, he left a total of 20,000 to my sister. That was what consisted of all his bank account monies. I'm not so sure whether my dad's intention was to leave only 20,000 to my sister, just simply because he intended to leave 50% of HDB. We live in Teck Whye. Teck Whye is an old estate. The HDB is probably worth 300,000+. So he probably wanted to leave 100,000+ to my brother. His CPF had about 100,000. He wanted to give me. I don't think that he wanted to give only 20,000 to my sister. So this is a real life example of even if you already are quite clear of what you want to distribute, without a proper death rehearsal, without proper planning, the intentions might not be carried out. Okay, so let's move on for my next view. In life, there's always 3 big unknowns. So what are they? Firstly, the question that nobody can answer, but everybody wants to know. When will I die? Secondly, what assets will I leave behind? Thirdly, who will finally get my estate? So there are 2 things that actually we can remove from this big unknown if proper planning is done. That is, what assets will I leave behind? Who will finally get my estate? When will I die is something that even when you plan for, you still cannot know. So we come to this very famous quote in China, 富不过三代. For those who are non-Chinese speaking, there's a UK version, clocks to clocks in 3 generations. Even the US has this search list to search list in 3 generations. So what they are essentially saying is that all your wealth accumulated in the first generation typically is spent by the second generation and will be gone by the third generation. Is that what we actually intended to do by the first generation? I don't think so. So I always share about this picture. Wise man built his house upon the rock. The house looks very sturdy. The rock also looks very sturdy. So we always want to ensure our foundations are strong before we start building our house. So why should I plan? There are quite a few reasons here. Let's go through them. What happens to my estate when I pass on? Is my estate protected from creditors? Post-death expenses. What can be distributed? What can be done to prevent dispute, minimize the time to distribute the estate? So these above 5 will be slowly explained through different case studies in the rest of my presentation. What I want to talk about is this final point. Who will take care of my child with special needs? So some of the attendees here actually know that last Friday I was invited to give a talk about special needs trust company, SNTC, that is specially catered to parents with special needs children. But in our context, in our current context, there's also a different kind of child with special needs. I typically term them as the S11 children. What is S11? As you all know, it is a money sign. So I'm not saying that they are money greedy. I'm saying that the child might not be financially capable of handling a lump sum of money at the point of inheritance. We have heard many stories in the news about 1 million, 2 million, 5 million, 10 million being passed down or even being crowdsourced to give some children who's in need. And quite often, 1 year later, everything is gone. So this is where planning actually comes in. So end of the day, who to distribute to? So I also mentioned about ISA, Interstate Succession Act, just now in my dad's view. When does it apply? It applies when the person dies interstate. So there are 3 conditions. A person is deemed to have died intestate if no will is made. If a will is invalid. So at this point, someone might be asking, what is an invalid will? Invalid will, one very important example is when there's no 2 witnesses. In a will, you always need 2 witnesses. If only one, it will be deemed to be invalid. So lastly, property not included in the will. This is self-explanatory. So as I've talked for about 5 to 7 minutes, I usually like to interact. So let's have a quiz time. Please put in the chat box your answer to this. So my question, first, if a person dies leaving behind spouse, children, and parents, who are the beneficiaries? A, parents, spouse, and children. B, parents. C, spouse and parents. D, spouse and children. So let me see the chat. I see A from EE. I see quite a lot of D's from the rest. Okay, so the actual answer is spouse and children. So I have always, before I ventured into will planning, I always thought the answer was A. Because when we pass on, we always want to benefit our parents, spouse, and children. But it was unfortunate I found out it's not the case. The actual answer is D, spouse and children. So let me explain further by going through a few scenarios. Okay, first, we are left with spouse only. So what happens in this case? Our spouse gets 100% of our estate. Second scenario, left with spouse and parents only. So in this case, our spouse gets 50%, our parents gets 50%. Thirdly, we are left with spouse and children only. This is like my dad. Spouse gets 50%, children gets 50%, remaining split among all remaining children. So what happens when we are left with spouse and children and parents, the one in the case study? Spouse gets 50%, children gets 50%. Parents get 0%. Is this the case for you if you actually want to leave behind your estate? I'm not so sure. So one more scenario, left with children and parents. The children will get 100%. The parents again get nothing, 0%. And the question always comes out is, what if the children are minor? What if the children are too young? Who is going to be their guardian or trustee? So in this case, it will be a strange scenario if, for example, the children get 100%, but the parents are asked to be their trustee. So there might come a case where there's a conflict where the parent is saying that, why must I be a trustee for the children when my own children didn't leave me anything? Okay, what do we have? First asset that all Singaporeans have, our house. So our house, typically, we will leave behind to three kinds of people. Firstly, our children. Secondly, our loved one or our spouse in this case. The third one is maybe our business partner. So another quiz in here. When I die, I give my property to charity and the rest to my son. What do you think is the intention of the mother? A, upon death, immediately give the property to charity and the rest of the estate to my son. B, upon death, allow my son to stay in the property for a period of time and then give the property to charity, the rest of the estate to the son. Okay, I see A, I see B, one more A from ST. Any more? Okay, I see another B. So there's a mixture, A and B. So I guess in this situation, there is no real answer in this case. It is more important to ask the intention of the testator. The testator is the person who writes the will. What is your actual intention? Is it A or B? It is not, yes, as Adeline says, it is unclear. So let's go through a case study based on this question. Okay, let's have a look at this case study about Madam Chia. So as the headline shows, she leaves 3.4 million to charity, $32,100 to children. So what happened in this case? There is Madam Chia, the person who passed away. There is his adopted son, Henry, who is the person who's smiling there, and another two adopted daughters, total 3 of them. So what did she give? She gave a 1.6 million house to charity, and she also donated 1.8 million in cash and 23,000 worth of jewelry. What did she leave to her adopted children? She left 30,000 to Henry, 2,000 to one of the 2 adopted daughters, and another adopted daughter who was not seen in many years was left with $100. So the issue here comes in that Henry and his adopted mother, Madam Chia, has been living together all the while. But upon her death, her will states this, which is where the question comes from. Is her intention actually to say, I want to donate my house to charity, but Henry is still staying inside. I want to let him stay inside until a certain age or until he has a house of his own, after which I will donate my house to charity? Or do you think Madam Chia's intention was, upon my death, I want to kick Henry out of the house and just leave him 30,000 to his name? So at this moment, nobody can know unless someone here has Madam Chia's handphone number up there, then maybe can give a call to her and ask. Okay, next, what do we have? We have bank accounts. Bank accounts are typically single-owned, jointly owned, or you have an offshore account. So when it's single-owned, it is easier to distribute because it's fully under your name. You can designate who to give to. The important part is to let people know how many bank accounts you have, because quite often Singaporeans now have quite a few bank accounts. Secondly, jointly owned. Jointly owned is sometimes a complicated matter to explain. To put it simply, it is the same idea as my dad's joint tenancy. The rule of survivorship rather always applies when there is nothing stated in a will or will is not drafted. So for example, myself and just now maybe say Adeline has a joint account, but actually this joint account is for business venture. Both of us put money in equally, but upon my death, actually my idea is I want to leave my whatever amount is there to my family, but I did not state so. So based on rule of survivorship, Adeline will be able to take over. Then offshore accounts. Offshore accounts is also able to distribute, but quite often is when you have an offshore account, what is the first thing that will happen is, does your family actually know you have an offshore account? Sometimes it's because of different countries, regulations and jurisdiction. The money might come back lesser than what you actually wanted to leave behind. So one more quiz. I think I accidentally gave the answer there, but let's go through this. I have a joint account with my friend. Upon my death, the money in the joint account belongs to who? It will form part of my estate for distribution. It will belong to my friend. So Adeline is smart because she already knows that it belongs to her. Anyone else? Anyone think it's A? Okay, so I see that everybody here is, oh, I have an A here. So actually the answer, end of the day, it could be A also, because it is to be according to the testator's intentions again. So we have to always be clear and concise in our will to state properly. Upon my death, I have a joint account with my friend. This money is supposed to form part of my estate for distribution. So when it's that clear, the answer will be A. So what happens when it's unclear? So let's look at this case study. In this case, we have a nephew, we have an aunt, who's the person who passed away. We have an aunt's boyfriend. We have a divorced husband. So what did she actually leave behind? She left behind the nephew properties. She left behind the nephew the hair salon that she opened. So the nephew actually got quite a lot of the inheritance and the estate already. But what happens in this case? The nephew actually appealed to the court because his aunt and his aunt's boyfriend had a joint account. In it, it was worth $345,731. So in the aunt's view, it didn't exactly say whether this joint account is to give to family or give to, as the nephew says, the lover. So nephew keeps saying that my aunt always puts her family first. So why should the lover actually get her savings? So after which she appealed to the court actually overturned the appeal, says that the boyfriend can continue to keep the money. In fact, he said that the nephew was greedy because he already got the salon, he already got the properties. So in this case, right, who is the correct beneficiary? What was the actual intention? Nobody actually knows. And also because the case was brought to court, this particular aunt was an SQ girl in the past. So she has a very good image, she likes to be very pretty, etc. But it turns out that she has a failed marriage that nobody knows. It turns out that she has a lover. All this was aired in public. And initially, she intended to leave behind all her estate to her husband, her former husband, Michael. So in this case, I would like to also highlight that a will is revoked upon marriage, but a will is not revoked upon divorce. So it might be important to review your will if you have made one and your current status is divorcee. Okay, this is a next case study. So I guess the hot topic previously in the news was these 3 words called KTV. So I thought I'll put up this particular case study here. KTV boss shooting death, but the importance is not on KTV. The importance is actually on the subject of mortgage insurance. For those of you who have seen this case back in 2007, it was a big hoo-ha. The KTV nightclub boss was shot dead, and it became known that the landed property that he was actually staying with his wife, the loan repayments have not been made. And the sad thing is there was no mortgage insurance in place. So what happened to the house? The house was actually put up for auction once and failed. and subsequently put an auction at a lesser value. So what is the bank doing here? The bank is trying to recover their loan by force selling the house. So for those of us who actually have a house and we have a housing loan and it's not secure, please have a mortgage insurance to secure it. So next is a famous celebrity, Anita Mui. For those who like Hong Kong shows or Hong Kong songs in the past, Anita Mui is not unknown to you. So in this case, Anita Mui died very early, as a lot of you all know. She actually passed away at the age of 40 out of cervical cancer. In her will, one particular instruction was very clear to her. She doesn't want to give her mom a lump sum. She wants to give her $70,000 a month for the rest of her life. So currently, why do you think she wants to leave her mom not a lump sum but $70,000 a month? I guess some of you who read the news previously know the answer. For those who not in the know, have a think. There is this particular country about an hour's flight away from Hong Kong, an hour's ferry ride. It's called Macau. In Macau, what is there? There are many casinos there. So yes, sad to say, Anita Mui's mom was a compulsive gambler. So Anita Mui was actually exercising good intention by creating a trust fund to give her periodic payments for the rest of her life. She is actually worried that if she gives her mom a lump sum, all of it will be gone through gambling within a short span of time. But what did the mom do after knowing about this bill? The mom actually went to appeal in court. She's trying to say that her daughter, who is Anita Mui, was not of sound mind when she made the will. She wants to lay claim on the entire estate for our own disposal. So after some of you might be curious, the end result was that the judge overturned her appeal, but the judge did increase the amount. It was increased from $70,000 a month to $120,000 a month for the rest of her life. One interesting fact in this case study is that quite often in our life, a lot of people are 30s, in their 40s, they always say, what is the point of doing a will? Even if I die, my parents probably won't survive me for very long. So maybe I just leave them a nominal amount, which is enough to cover them for maybe the next 10, 20 years. At this point in time, I would like to give an impromptu quiz. Anyone wants to make a guess to the age of Anita Mui's mom right now? She's still alive, so please don't tell me she is 60 and passed away already, or 84 as in the case study. Anybody want to venture a guess? You all can put in the group chat. 90, 70. Any more? Okay, so the actual answer is she's actually 97 right now, 97 years old. So she has survived her daughter by 57 years, more than double of her daughter's age when she passed away. In fact, 2 years ago, back in 2019, for her 95th birthday, she appealed to the court, and the court granted her a one-off payment from the trust fund. Yes, the trust fund is still very valid after 50 plus years. The court granted her a one-time payment of $250,000 for her to celebrate her birthday. So it is entirely possible that our parents will long live after we are gone. So next, what else do we have? Some of us are business owners here. So business owners typically are either you are the sole proprietor, you have a partnership, you have partners in your business, or you are private limited. So what are the potential disputes or conflicts that we can resolve earlier if we have planning? Let's take a look at this. Minority shareholder in family company sues aunts and uncles in bids to cash out. So you notice that the minority shareholder is a 49-year-old man, but the aunts and uncles are 70s and 80s. Oh, so what does this mean? The 49-year-old man has an inheritance from the father, who is the siblings with the aunts and uncles. So what he's saying here that he's trying to sue for them to buy out him because he says that the aunts and uncles who are the directors, who are the main decision makers in the company, have been paying themselves unnecessary fees and remuneration. He's saying that dividends are not paid, so he wants out of the company. But you realize that in the first line of the article, this company is asset rich but inactive. So what does this mean? Usually when you hear the word asset rich, the other part of the story, sometimes it means cash poor. So it is possible that the nephew wants out, but the family business is unable to buy him out. So the next few that we have our stocks, we have our insurance policy, we have our car, we have our price painting, and lastly, we have CPF. So all of these are also considered part of our estate. For CPF, you already understand we need to do a CPF nomination. Similarly, for insurance policies, stocks and shares, there are certain companies that can do nomination, certain companies that cannot. But quite often, it is the same case as bank accounts. Do your family know how many stocks accounts you all have? And what's the nominal value in? That's an important part that we need to state. For paintings, sometimes the painting value fluctuates, depends on the time, depends on the valuer. As for cars, many people always say it's a depreciating asset. So what are some of the complications? We always think wealth accumulation is the tough part. But in actual fact, the reality is that 4 Ws is even tougher. So what is the 4 Ws? Wealth distribution, wealth protection, wealth equalization, wealth enhancement. So what do I mean by these 4? Let's take a look at this. Wealth cannot last without protection. How many of you all actually know this hotel? Kanyu Hotel. It's no longer there. It was back in the 1970s. It was first known as Regency Hotel. After that, took over by a company made to Kanyu Hotel, subsequently sold off. And next, a more recent hotel, Le Meridian. The owner was actually made bankrupt because of alleged mismanagement of funds, not good business dealings, etc. So without protection, even if we are actual hotel owner, it also doesn't last. Let's take a look at what happens when we pass on the actual timeline. So while we are living, assuming we have an asset of 8 million, we have a liability of 4 million. So we have planned very nicely. Our assets exceed our liability, no issue. Even if we pass on, also no problem. So is that so? So upon the set RAP, our assets are actually frozen upon death, but liabilities continue. So there is a potential case of you having money, your liabilities being there, but your family cannot utilize the assets until probate is granted. So typically, when you have a will, it's called probate. When there's no will, it's letter or administration. It takes about half a year to the quickest to be out. Then after death, there's typically immediate expenses like the funeral, your outstanding medical bill, credit card loan, house loan repayment, family expenses. On top of this, actually, I want to point out that obituaries are actually quite expensive. The one that you saw for my dad was a very, very small one in the newspaper that cost 3,000 plus. At that point in time, I inquired, a full page cost probably more than 12,000, which at that point in time I couldn't afford. So like I said, about 6 months, issue a probate. And finally, if the 6 months, our liabilities are able to be settled, our immediate expenses are able to be settled, our estate will then be able to distribute if everything goes smoothly. Okay, so next, let's talk about wealth protection and enhancement. So I guess everybody knows this person is Albert Einstein. So why is he here? Normal people always say 10 equals to 5 plus 2.5 plus 2.5. That's correct, logical, rational. But Einstein is a genius, and we are all geniuses here because we listen to this. What if we can make 10 equals to 8 plus 5 plus 5? So how do we do that? Wealth enhancement. So when we have a big lump sum of money, for example, 10 million, what can we do? We can, through an insurance policy, we can create many different sets of amounts of money that will exceed the initial value of whatever we put in. So insurance helps to enhance our wealth. Wealth equalization. Let's take a look at this case study here. This particular client has a 5 million property, another property worth 2 million, cash investment worth 3 million. In a normal scenario, without a will, without proper planning, this client probably upon death, what will the family do? The family will do this. They will sell away the cash investment. They will sell away the property. They will sell away the 5 million property, the family home. Why would they do that? Because they want to ensure everybody gets an equal share so that there's no dispute. What is a better way that actually we can do this? Firstly, we can put the 5 million property, which is likely to be the family home, into a trust. So it will ensure that the family has a home to stay forever. We can also buy an insurance policy, use it to equalize among all the different surviving family members in which everybody gets an equal share, utilizing the enhancement feature of insurance policy, and we can even have some left behind for charity. So next, we talk about wealth transfer. Our estate is essentially a gift for our loved ones. We are transferring the wealth that we accumulated, that we created, that we worked so hard for through the course of our lives to transfer on and make our next generation better. So when is the best time to do this? To me, I always tell my clients, everything happens at the right time. When my dad passed away, it's the right time. When I came into this industry to specialize in will planning, it is the right time. You are here to attend my own will planning seminar, it is the right time. So the time is now. Or alternatively, if some of you might say, no, it is not the right time for me now. So there's two other times. Some of us will identify the family as the guy on the left. Some of us might identify the one with the lady on the right. Some of us might be at the edge in the middle. I don't think any of us are the kids there. So which is the proper time? You all decide. The last one, I'm sure you all understand what this is. This is a flower wreath. So at this point in time, it's definitely the right time to act. But sadly, sad to say, we can't act anymore at that point in time. So how sure are we that our loved ones will get what we intend to give? Do we want to see it as in the picture, a tug of war, or we decide now? What is a perfect gift for our loved ones? We can leave behind a gift, a present to ourselves, to our loved ones now. Lastly, we come back to this picture. Wise man built his house upon the rock. Why do I show this again? Because we always want to talk about foundation. So this is the actual house. Even at low tide, you see that there is a very solid foundation over there. This is the kind of house that we want to build. On the other hand, if we put it at the same high tide, the house actually looks grander than the one on the right. But after the low tide comes in, you'll notice that the foundation is actually quite shaky. Just two skinny legs over there, which is the house that we actually want to have. Review our foundation regularly. So how can we help in this case? I can help by doing a LPA, lasting power of attorney. I can help by doing a will. I can help by setting up a trust. And I also can help provide the funds necessary for ensuring our intentions and wishes are carried out upon death. So what is next? At this point in time, I would like to share about a research study that I went through previously about human memory retention. What I understand from them is human memory retention typically has a span of 72 hours. If we fail to act upon some new knowledge in the next 72 hours, quite often we will forget and start losing memory of what new knowledge we have gained. So I would like to share in this case that since we are here, will planning is a must for everyone. Spend some time thinking about how this can actually affect yourself and also affect your family, your business partners, your children down the road if it's not properly planned for. And with that, I come to the end of my presentation. Any questions? I noticed some of it is in the group chat, so I'll answer it for a while. And this is my handphone number.
All right. Thank you so much for sharing, Roger. Right now, we are opening to the floor for the Q&A session. And I think previously there's already one existing question being asked by one of the audience. What if the spouse passes away before you and you have children?
Okay. I see the person is Alvin. So Alvin, I'm not so sure if your parents are still around. In the scenario that I painted previously, if the spouse passes away before you, that means the surviving spouse will get 50%. 50% will be distributed equally to the surviving children. Parents will get 0% if nothing is indicated.
All right. We hope Roger answers your question. Do we have any other question? So any issue if the witnesses of the will are no longer around?
This is quite often when a will is made. I must first go back to a quick background. When a will is made, it is not 100% not challengeable. All wills can be challenged. So what do we want to ensure in this case is the witnesses, if there's a challenge, right? Quite often what they will go is they will go to the court. The court will go and ask the witnesses. So your question, if the witness is no longer around, is it both witnesses are not around or is it just one of them? If both of them are not around, it will be likely revert back to the court to go and decide. So it will be based on evidence. It will be based on different kinds of things presented. And one particular thing that sometimes we can use is a video recording. If there is a concern that the witness is an old person that's potentially no longer around, etc., you can use a video recording, take a recording of the entire will process and present it as evidence if needed.
So we have another one. For Anita Mills' case, what happens to the balance of the trust fund after her mom passed away? Does it go to the government?
This is a very typical Singaporean question. Whatever happens, we do not want our estate to go to government no matter what. It must go to somebody. So I would say that actually Anita Mui has planned her will quite well. Why is it so? Because her actual will content is not only the 70,000 to a mom. There was also education fund set aside for her nephew up to the tune of 2.5 million. And whenever there's a trust set up, in this case, a trust fund, we will always talk about termination of trust. So in this case, I guess Ming Xing's question is what happens when the beneficiary pass on? So in her actual will, she has already stated that I will give $70,000 per month to my mom for the rest of her life. After she passed on, the trust will terminate. What is left of the balance of the trust amount will go entirely to charity. So this is what happens to her actual trust fund down the time when her mom passed on. Her mom is 97, so likely this is going to happen. So when we set up a trust fund, we will always ask you what will happen after beneficiaries pass away. What are your intentions when the trust is terminated?
All right. Do we have any other questions? We still have some time for a few more questions, maybe 2 to 3 questions.
I see a private message to me from Alvin. So Alvin, unfortunately, I don't have LinkedIn. So it might be useful for you to text me on my mobile number, then we can connect further.
Yeah, so if you would like to reach out to Roger, let me drop some links. There are a few areas that you can reach out to him. Okay, one of it is like askexpertsanything.com, or you can reach out to him via Facebook or even his phone number. So we have another question from Adeline. Is it true that validity of wills and revocable nomination depends on the timing of either document?
Okay, this question is a common question. The answer is actually yes. The answer is actually also no. So quite often when we have this issue comes up is some people will always talk about timing. So we will say the will comes after the nomination is made. So the will should be valid. Yes, it is true, but it is also not true if end of the day we realize that the actual intention is discovered to be otherwise. So what is important in this case is during the will planning process, we will actually go through if nominations have already been done on certain policies and whether the instructions in the will will have a conflict, will cause a conflict with the nomination. Typically in a simple will process, we might even suggest that because if there's a no nomination, let me repeat, if there's no nomination, insurance policies will automatically flow to the estate. So the estate will follow the will if the will is already properly planned for. If there is, for example, a particular thing that we want to do, maybe saying that this insurance policy is to, of 1 million is to pay off my mortgage loan upon my death. This is what I talked about during immediate expenses because the loan continues, but money doesn't come out yet. So it could be that they are used concurrently. It could be that they are in conflict. So it is important to ensure they are not in conflict.
Okay, we have another question from Randy. Like those e-insurance, will there be e-will be offered?
E-will be offered. I'm not so sure what this means. Randy, are you there? Maybe you want to unmute and explain further.
I think Randy is a bit shy.
Oh,
he's on the
train. E-insurance, I'm not too sure, so I can't really answer. But as I would like to say, as long as you are the policy holder of an insurance, so I'm taking out all those that are under group insurance, like for example, your company has insurance for you. For example, etc., etc. As long as you are the policy holder, the will will likely be valid. But if you're asking about e-will, I'm not so sure what is this.
Yeah, see, it's okay. It's like signing a will digitally.
Signing a will digitally. Okay, so the current status of our wills most of the time, in fact, I'll say all of the time right now is it should actually be valid and able to do digital wills. So, but if you want, you can connect with me separately. We can talk about this. What I understand is because of with the pandemic, there has been situations where Zoom appointments are arranged. Then you are in the presence of two witnesses. Then you sign in front of them. So it is possible to do now. But I guess the actual issue comes out is when the will is challenged, whether it is actually valid. It should be valid, like it should be valid. In this case, we have cases where people use Zoom to e-sign.
Okay, we still have a bit of time maybe for one last question after this. So from Austin, how do we know that someone has made a will? What happened if the will surfaced after the estate distributed the inheritance?
This is a very interesting question. So some people have told me, Roger, after I do my will with you, can you don't tell my family? Because this will is supposed to give to other people. This will is supposed to give to people that I don't want my family to know, etc., etc. So I always say, as long as you have made a will, right? In the will, you have your executor, you have your beneficiaries, etc., etc. The most important is at least let your executor know the existence of the will, because that person is the person who will execute your will. If he doesn't know, or she doesn't know, he or she is supposed to execute your will, then likely what will happen is they might take it that there's no will, because nobody knows. If not, if no matter what, right, cannot let the executor know, keep the will with your best friend, whoever is your best friend, your close friend. Or you can put your will in a place where someone will definitely be able to find, maybe say under your pillow. I'm not so sure. So end of the day is we need to have someone at least know of the existence of a will. If not, it won't be so useful in your estate distribution down the road.
Interesting. What about if, let's say, you do not have any children and you only have one spouse, and just happen that both spouses die at the same time? I know it's very rare, but let's say, where will it go?
So it is a couple, husband and wife.
So for example,
both with no children.
No children, but got into an accident or whatever. So yeah.
Pass away at the same time?
Yeah. What will happen in such cases?
So quite simply, first, are the parents still there?
So let's say the only people that are around, maybe their siblings. Yeah.
So no more parents.
Yep.
Okay. When this thing happens, it is called a joint disaster. When a joint disaster happens, right, you will look at the date of birth of the couple. So whoever is the older one, for example, the husband is the older one, we will deem him as the older one to pass away first. So his estate will distribute first. So in this case, no parents, you will go to siblings.
Oh, okay. I see. Okay. We have a bit of time for one last question here from Randy. If I have two wives and families, do I need one will or two if I don't want them to know about each other?
I guess, Randy, you can, it seems to be a continuation from Austin's question. Because when you have two wives and two family, I understand the concern. That is a hidden thing that I was sharing just now. Some people make will, they tell me they don't want to let their family know. So first question I always ask is it because you have a second family? So sometimes the answer is yes. So in this case, this is the same exact scenario lah. So what happens is you can have two separate wills. One for your existing family, no, existing is the wrong word. One for your family number one will for your family number two. Yeah, but the important thing is these two wills, when you do, typically in a will, what always happen in the first line is, this is my last will and testament. I hereby revoke all codicils, all previous, etc., etc. It's important that both wills don't do this. If not, the will will always follow the latest will. So the will must not have that particular instruction. So you can have two separate wills. You can execute them separately, or you can do a combination of a will and a trust. So end of the day, your trustee distribute according to your wishes, your executor executes according to your wishes. And always pray in this sense that in this case, don't put your will in a place where it's super easily found. It's a different thing totally from just now. Because if your first wife finds that your two wills, even you have two will, unlikely your other wife will know about the existence of the other will anymore. It will either be burned, be torn up, or something like that.
Yeah. So Randy, be careful about that.
Oh yeah, I see Randy's
young man's mistakes.
Okay.
All right. I think that's all from Roger. If you have more like questions regarding will planning, anything regarding will, please contact Roger. Let me resend the links over in the Dropbox, as in chat box. All right. So if you want to find out more events like this, you can actually stay up to date with Xpreneur.